Welcome to the deep dive. Today we're getting into something really fascinating and honestly quite challenging. We're looking at classical Athens, the birthplace of democracy. But we're focusing on a huge contradiction right at its heart, the status of women under Athenian law.
It really is a study in contrast, isn't it? You have this explosion of political thought, this radical idea of the self-governing citizen. But it seems that idea was built on a foundation that kept, well, half the actual citizen population in a state of perpetual legal dependency.
Perpetual legal dependency, that's the phrase, isn't it?
Yeah.
They just never existed as independent legal people.
Never. Always under the control of a male guardian, the kyrios.
Right, the kyrios. So our aim today isn't just to list off all the things women couldn't do, like own property, make contracts, go to court themselves. We know those basics. We want to dig deeper. We want to understand the specific, maybe narrow ways protections did exist, or how women, or rather their guardians, could navigate the system. We'll be looking at legal procedures, philosophical debates, the whole picture.
And to really grasp how extreme this control was, you need that figure of the kyrios front and center. First the father, then the husband. Maybe a son, even another male relative if the others weren't around. That structure shaped absolutely everything for an Athenian woman.
And what's really striking, as you mentioned earlier, is how the law changed for men, but just stopped for women. You compare it to Rome with the patria potestas, that powerful father figure controlling sons, sometimes for life. But the sources suggest Athens moved past that fairly early for sons. That sort of unlimited subjection faded.
It did. Athenian men, once they reached maturity, they were citizens. Full stop. Legally free.
Yeah.
But that evolution just never happened for their sisters, their wives, their daughters. They stayed under the kyrios.
So the logic was what? Just deeply patriarchal. Women couldn't handle things.
Pretty much. The underlying assumption seems to have been pragmatic from their perspective. But yeah, deeply patriarchal. Women were seen as fundamentally unable to manage big estates, or handle significant contracts, or operate in the public legal world.
So the kyrios wasn't just a father figure. He was a necessary manager. Forever.
The perpetual legal representative. It cemented the woman's status as effectively a legal minor, invisible to the courts except through him.
Physically present, legally absent.
Okay,
so if she couldn't contract her own property directly, how did her money, her wealth, actually interact with the law? How did that work?
Right, that's where the dowry comes in, the pro. It's absolutely crucial.
The dowry.
She didn't own it like we think of ownership today, but it was legally tied to her. It was meant to support her during the marriage, provide for her financial security, and critically, it was supposed to be recoverable.
Recoverable. So even though she couldn't sue herself, the fact that the dowry could be recovered meant her male guardian, her kyrios, had a legal tool, a way to act for her.
Exactly. It gave her a sort of proxy voice in court purely through the mechanism of the dowry. And these weren't just theoretical ideas. These were actual legal procedures used in Athenian courts. Very important ones.
Like what? What were they called?
Well, the main one was the epikleros. That's the specific lawsuit for getting the dowry back.
When would that happen? Divorce?
Usually, yes. Divorce, or if the husband died. The woman's family needed that dowry back for her support or, potentially for her to remarry. It was her financial anchor.
Okay, so that covers getting the lump sum back. But what about day-to-day living? What if the husband just wasn't providing?
Well, that links to the second key action, the dike situ. Situ literally means of grain or of food.
So a lawsuit for food money.
Essentially, yes. It was a procedure to recover maintenance, basic living expenses directly from that dowry fund. You can imagine maybe a marriage breaking down, husband's irresponsible, not providing. The wife's kyrios could sue to get regular payments drawn from her dowry money to keep her going.
Wow. So the law did have mechanisms to stop a woman being, completely abandoned financially, even within the marriage.
It seems so. We have evidence suggesting both epikleros and situ cases happened. They were real, actionable concerns. It shows that while she was dependent, the system had some checks against the kyrios, usually the husband, just completely failing his obligations.
Okay, that makes sense. But courts mean witnesses, right?
Yeah.
Especially in messy family disputes over money.
Yeah.
And I've heard the Athenians had issues with witnesses.
Oh, absolutely. This is one of the most counterintuitive things about their legal system. They were deeply, deeply skeptical about free witnesses.
Free citizens. The guys voting in the assembly, they didn't trust them.
Generally speaking, the assumption was they were inherently unreliable. That's the phrase used. They figured citizens were motivated by self-interest, political alliances, personal hatreds. They expected people to lie under oath for friends or against enemies.
That's quite an indictment of their own democracy. Was this just a feeling, or was it built into the law?
It was institutionalized. They had a specific legal action called the pseudo-martyrion. It was an action against a witness for perjury, for lying under oath. The fact they needed such a serious procedure with potentially harsh penalties just highlights how much they distrusted testimony.
So if you had conflicting testimony from free citizens, which must have happened all the time, what did the judges do? How did they decide?
They looked for what they called better proof.
Better proof. Okay, what qualified as better proof than a sworn oath from a citizen? This sounds intriguing.
This is where it gets really jarring, especially for us today. They turned to the testimony of slaves.
Slaves? But how? Why would a slave's word be better?
Under one very specific brutal condition: torture.
Wait, testimony obtained under torture was considered more reliable than a free citizen's oath.
Yes, the sources explicitly state that testimony given under torture by slaves was seen as a reliable way, even better than witnesses.
I need a second to process that. In the world's first democracy, built on citizen freedom, they valued forced testimony extracted through violence more highly than a citizen's sworn word. What was the thinking there?
It seems to boil down to a kind of extreme cynicism. The theory was, supposedly, that the free citizen was too free, too driven by self-interest, by political feuds, what one source calls institutionalized aggression, basically using lawsuits as weapons in ongoing feuds. They believed the citizen would lie to win.
Okay, and the slave?
The slave, theoretically, had no personal stake, no political agenda. Subjected to extreme pain, the idea was they'd be stripped of any reason to lie and compelled to state only the bare facts. Pain guaranteed truth, in their view, while freedom allowed for strategic dishonesty.
That is deeply disturbing. It suggests they almost distrusted the very freedom they championed, seeing it as a source of legal chaos.
And this wasn't just theoretical. This use of torture for slave testimony happened, especially in really serious cases like disputes about legitimacy or inheritance, where witness accounts often clashed. It shows how high the stakes were and how profound that distrust of the free citizen really ran.
Okay, moving from the general financial framework and the weirdness of witness testimony, let's talk about inheritance more directly. There's this unique figure, the epikleros.
Ah, yes, the epikleros. She's probably the most legally complex female figure in Athens. She wasn't an heiress in our sense, inheriting property to control freely.
The name itself, epikleros, means something like attached to the property or upon the lot. Yeah.
Exactly. Her status was entirely bound up with the family estate, the oikos. Her existence was legally tied to a compelled marriage.
Compelled marriage?
Yes. If a man died leaving only a daughter, she became the epikleros. Her primary legal function was to marry her nearest eligible male relative.
Her nearest relative. Not her choice.
Not her choice. The goal was purely to keep the family property within the lineage, and crucially, to produce a legitimate male heir in the next generation who would then inherit the oikos. She was the conduit, the vessel through which the property passed to the next male owner.
Her personal feelings were irrelevant.
Legally speaking, yes. The continuity of the male line and the oikos was paramount.
Okay, that sounds like a system designed to keep wealth concentrated within families. But what if the family wasn't wealthy? What about the poorest citizens, the theits class? What if the estate was basically nothing?
That's a great question, and the law did account for that. It shows a pragmatic side. If the epikleros belonged to the lowest property class, the theits, where the inheritance was negligible...
The relative wouldn't exactly be getting rich by marrying her.
Precisely. So the law gave the next of kin, the ankistius, a specific choice. He couldn't just ignore her.
What was the choice?
He had to either marry her himself, taking her into his household, or provide her with a dowry of a minimum value set by law.
Ah, so he couldn't just leave her destitute. He had to either take responsibility directly or give her the means to marry someone else.
Exactly. It was a safeguard, probably to prevent women becoming burdens on the state just because their inheritance wasn't worth fighting over. It forced the male relative to act responsibly one way or the other.
That's quite practical. But if the epikleros was wealthy, she sounds incredibly vulnerable. She's legally dependent on the very men who stood to gain most by cheating her.
Right. Absolutely. The potential for abuse by male relatives was obvious, and the system recognized this danger.
So were there specific legal protections against relatives trying to, say, siphon off her property or marry her off improperly?
Yes. There was a very serious public charge available. The Isangelia kakshos epikleron.
Okay, say that again. Isangelia.
Isangelia kakshos epikleron. Kaksosis means something like ill treatment or abuse.
Physical abuse.
It could include that, but in this context, it specifically meant abusing her rights regarding the estate, mismanaging it, marrying her off wrongly, basically failing in the legal duty towards her and her property.
And you said it was a public charge, an Isangelia. Isn't it usually for things like treason?
It often was, yes. Using such a high-level public prosecution mechanism for mistreating an epikleros shows how seriously they viewed this. It wasn't just a private family matter. It was seen as an offense against the proper order of society and the legitimate transfer of property.
So anyone could bring the charge, not just her guardian.
Potentially, yes. That public nature acted as a powerful deterrent. Your dodgy dealings with the heiress relative weren't necessarily going to stay quiet within the family.
And we even see hints of this whisk in other sources, like plays.
Definitely. The playwright Menander, in his comedies, touches on this. He portrays situations where it's seen as incredibly foolish or downright illegal for the next of kin to try and pull a fast one, like marrying off a rich epikleros with a tiny dowry while keeping the valuable estate for himself.
Why was it foolish?
Because the understanding was, if he did that, any son she eventually had, once that son reached adulthood, that son would have full legal standing to sue the relative for the full value of the estate that should have come with his mother.
Ah, so the check wasn't the woman herself, but the threat of future legal action by her potential male heir.
Precisely. It's a fascinating example of protecting the woman's interest indirectly by leveraging the future rights of a male citizen. The system policed the current guardian through the potential claims of the next generation.
Okay, we've covered the economic side, dowries, maintenance, the epikleros. Let's shift to safety, violence, and honor. When a woman was wronged, physically or sexually, how did Athenian law frame it? Was it about her injury?
Almost never directly about her injury or her experience. The dominant legal framework was hubris.
Hubris, we hear that word a lot, usually translated as pride or arrogance, but legally it meant more like outrage or insolence.
Exactly. Wanton violence, acts intended to shame and diminish someone's status. And when it came to acts against women, it was primarily prosecuted as hubris against her male guardian, her father or husband. His honor was the thing legally violated.
So an attack on her was seen as an attack on him.
Primarily, yes. His social standing, his control over his household, that's what was legally damaged and needed redress.
Aristotle apparently talked about acts of hubris that victims might be ashamed to disclose. What kind of things fell into this?
Well, in his writings on rhetoric, he uses examples like serious offenses against a man's wife or his sons. This included things like rape, adultery, and interestingly, even consensual homosexual acts involving sons. If framed as an act of dishonor against the father, the common factor wasn't just the physical act, it was the public shaming, the outrage inflicted on the male head of the household.
That distinction is crucial. It's about the impact on the man's honor.
Yeah.
So how did the law differentiate between, say, rape and adultery? Both seem like hubris against the husband.
They were both considered hubris against him, yes, but they were treated differently, largely because of consent and legitimacy. Rape, buyout, was understood as non-consensual. It was punishable, often by a fine paid to the guardian as compensation for the outrage against his authority and property rights over the woman.
A fine. That seems low.
From our perspective, certainly. But adultery, moicheia, even though it involved the woman's consent, was seen as far more serious.
Why? Because it messed with inheritance.
Exactly. Adultery threatened the legitimacy of children. It struck at the very heart of the oikos, the family line, the certainty of who inherits. That was a fundamental threat to the social order.
And you can see this focus on the husband's injured honor in the court speeches that survive.
Absolutely. You read speeches like those attributed to Lysias, where an aggrieved husband goes on and on about the hubris of the adulterer. It's all about the insult, the outrage, the damage to his status. The woman's experience is secondary, if mentioned at all.
And because it was about his honor, the law allowed him certain forms of, let's call it self-help, revenge.
Yes. The law concerning adultery is particularly stark here. If a husband caught an adulterer in flagrante delicto in the act with his wife,
What could he do?
he was legally permitted to kill the adulterer on the spot.
Kill him with no trial.
Kill him. Or, if he chose not to kill him, he could inflict other forms of punishment, other forms of hubris. Xenophon explicitly says the caught adulterer would be subjected to hubris by the husband. It was a recognized right to restore his honor through violence or humiliation.
Humiliation. What kind of things are we talking about?
Well, there's a notorious reference in Aristophanes' comedies to something called Raphanism.
Raphanising. What's that?
It implies shoving a large radish into the adulter's anus.
Seriously. That's incredibly specific and brutal.
It is. And while it's in a comedy, the joke only lands if the audience recognizes this as a known, albeit extreme, form of sexual humiliation that adulterers might face. It was about maximum degradation to match the perceived offense against the husband's honor.
Let's just sit with that. State-sanctioned killing or extreme sexual humiliation as a remedy for adultery. It really underscores that the legal system's priority wasn't the woman's safety or feelings, but restoring the male citizen's honor by utterly shaming his rival. A brutal code underpinning the democratic ideal.
It reveals a very different understanding of justice, deeply tied to personal status and violent retribution.
Okay, so we have this system. Legal dependency, but crucial for property, protection, but framed entirely through male honor. What about the philosophers? Did they just accept this? Did thinkers like Plato imagine anything different for women?
That's a great transition. Plato, particularly in his later work, The Laws, does offer a vision that radically departs from Athenian reality.
How so?
Well, for starters, he legislates that boys and girls should be taught dancing and gymnastics together. That alone was unconventional. But more strikingly, he argued women should also receive training in military exercises and drill.
Military training for women. In Athens. That sounds revolutionary. Why did he propose that? What was the point?
His reasoning was quite practical, actually. It was about the security of the state, the polis, and the household, the oikos. He argued women needed to be trained so they could actually defend their families and homes in case of extremity when the men are gone out to battle. He wanted them to be capable defenders of the home front.
So not about equality in our sense, but about practical defense capabilities. Did he contrast this ideal with how things actually were?
He did, quite stavingly. He criticized the women of his time who, lacking training and perhaps courage in his view, would just run to the altars in a crisis. He saw this as shameful, degrading man below the level of the animals because even female animals fiercely defend their young.
Wow. So he saw the current state as a moral failing, a lack of preparedness. It suggests at least some philosophical expectation that women could and should be more civically capable, even if the laws prevented it.
Exactly. It shows a tension between the legal reality and at least some strands of philosophical thought about women's potential.
This brings us to the really thorny question of female agency, especially when women acted against the grain, violently. How did Athenian thought grapple with female responsibility? The classic example has to be Clytemnestra.
Whoa, absolutely. Aeschylus's Oresteia trilogy is ground zero for exploring Athenian anxieties about female agency, cause, and legal responsibility or the lack of it, and Aishos.
So Clytemnestra kills her husband, Agamemnon. How does she frame her own actions?
It's fascinating because she shifts. First, she makes this incredibly bold, direct claim of personal agency. She stands over the body and says something like, "This is the work of this, my right hand." Clear, unambiguous responsibility.
My right hand. Very physical, very personal. But then she backs away from that.
Almost immediately. She then tries to deflect. She attributes the murder not to herself, but to an external force, the ancient, violent spirit of vengeance of the house. A demon, essentially, that just happened to take her shape.
So from I did it to a demon possessing me did it. That's quite a pivot. How does the chorus, the voice of the community, react to this?
Their reaction perfectly mirrors the city's philosophical confusion. They oscillate wildly. First, they seem to accept a kind of divine determinism. They declare that ultimately everything is God-determined by Zeus, calling him Panaitios, all responsible.
Panaitios, all responsible. So if Zeus is responsible for everything...
Logically, the human agent, Clytemnestra, should be Panaitios, not responsible, free from blame.
But they don't go there, do they?
No. In the very next breath, confronted with her claim about the daemon, they pull back. They can't fully commit to absolving her. They challenge her directly, asking essentially, okay, but who's going to testify that you aren't responsible for this murder?
So they're caught between fate and free will, divine responsibility and human action. And the figure forcing this impossible question is a woman who committed the ultimate transgression.
Precisely. It reveals this profound uncertainty, this deep contestation within Athenian thought. They recognized women, despite legal constraints, were capable of decisive, world-altering action. But they seemed to lack the consistent philosophical or legal framework to fully assign responsibility, especially when that agent was female and the act so monumental. It's a tangle of blame, fate, agency, and deep-seated doubt.
What a journey. This deep dive really lays bare a legal system just full of contradictions, doesn't it? On one hand, the Athenian woman is legally silent, a perpetual minor needing a kyrios for almost everything public.
Contracting, lawsuits, managing any significant property she needed him.
Yet at the same time, her existence, her legal status, was absolutely fundamental to how the whole society worked, especially property.
Absolutely critical. The entire system of transferring wealth between male generations through the dowry and the institution of the epikleros hinged on her specific legal position. And her physical body, her honor, was protected by law but indirectly framed as an offense against her male guardian's honor, his hubris, sometimes justifying extreme responses.
It really exposes that core paradox we started with. The society that gave us radical democracy, this ultimate experiment in citizen freedom, was simultaneously built on and arguably required a legal structure that guaranteed lifelong dependency for its female citizens. The freedom of the male citizen seems legally intertwined with the dependency of the female citizen. Thinking back to that shocking point about witness testimony, the deep distrust of the free male citizen.
Right, the idea that his testimony was inherently unreliable, that litigation was just institutionalized aggression, a form of feud, and that the tortured testimony of a slave was somehow considered better proof, more reliable.
It paints a picture of Athenian society deeply cynical about its own lauded citizen freedom, doesn't it?
It does, and it leads to a really provocative final thought for you, the listener, to chew on after we finish.
Okay, let's hear it.
Given that the Athenians themselves recognized that the legal freedom and agency they gave to men often resulted in this chaos, endless lawsuits, perjury, aggression, and that they distrusted citizen testimony because of it.
Yeah.
Could it be that the legal system deliberately limited women's public agency, kept them in that state of dependency, precisely because they believed that managing the inherent instability and untrustworthiness of male citizen freedom required keeping the other half of the citizen body under tight control?
So, was confining women legally not just a byproduct of patriarchy, but maybe an implicit strategy, a way to maintain some kind of civic order in the face of what they saw as the destructive potential of male freedom?
Was the legal dependency of women seen, perhaps unconsciously, as a necessary counterweight to the perceived chaos of male democracy?
That is definitely something to think about. A challenging end to a challenging topic. We'll leave you with that thought. Join us next time for another deep dive.